Today, we are going to discuss a fairy tale about a loving father and his three wonderful children and the evil stepmother who's hell-bent on stealing her stepchildren's inheritance. Hi there, my name is Stephen Terman. I have more than 20 years of experience as a trial attorney and appellate advocate in New York. I am the founding member of Terman Legal Solutions, which is a boutique law firm that specializes in trust and estates litigation, administration, and planning. Today, I'm sharing with you a story about a man named George. When George was a handsome young man, he was married to a beautiful woman named Martha. Together, they had three children, Alfred, Betty, and Carol. Unfortunately, Martha passed away when George was just 35. After Martha passed away, George focused all of his attention on raising his children and building his business. As the years passed, George's children grew up, they married, they started their own lives and their own families. George ultimately sold his successful business, and by the time he was 60, his net worth was in excess of $20 million. George, being the responsible man and loving father, wrote out a will leaving everything he had to his children equally. George also decided it was time for him to enjoy life for a change. 5 years later, George met Elvira, a 35-year-old former actress and model who swept George off his feet. She said all the right things, and she knew just what to do to make George's toes curl, if you know what I mean. Unfortunately, Elvira's looks and charm were only skin deep. Elvira had a dark side. As much as George loved Elvira, she was enraptured with George's money and all the Chanel pocketbooks it can buy. Of course, the main obstacle between Elvira and George's money were his three adult children. Elvira knew she had won over George's heart. Believing himself to be lucky in love, George wasted no time, and within a few months of meeting Elvira, he proposed to her. Elvira accepted. Before they were married, though, George did do a smart thing. He asked Elvira to sign a prenuptial agreement that would provide for her security and ensure that she would be taken care of should George die while they were married. It also provided her with some maintenance while they were married and in the event of a divorce. George thought he was being generous, but Elvira was less than pleased. Nevertheless, Elvira is a shrewd woman. She's cunning, and she kept her feelings to herself. She could play the long game, and Elvira always gets what Elvira wants in the end. So Elvira signed the prenup with her dark-hearted smile, and a few months later, they were married. Unfortunately, 2 years after the wedding, George was diagnosed with brain cancer, and his prognosis was not good. Elvira would now finally get a chance to strike. Again, Elvira's playing the long game. So she isn't going to do anything too rash that would set off alarms. Elvira initially played the role of loving wife. She took George to all of his doctor's appointments, making sure that he ate, drank, got a little exercise, slept, took all of his medications. To George and the rest of the world, this might even look like genuine love and compassion. Elvira's motives, however, were far from noble. While taking such good care of George, Elvira never missed an opportunity to complain about his lousy three children, and how shocked she was that the children were never there to support George in his times of need. In reality, George's children call him regularly. Elvira would pick up the phone every single time and tell them George wasn't feeling well. George was asleep. George couldn't come to the phone. He was in the bathroom, or he was otherwise indisposed. Of course, Elvira never gave George the messages that his kids called, so she would make excuses why the kids couldn't see him, and those excuses always seemed plausible. Essentially, Elvira was serving as George's gatekeeper and ultimately George's jail warden, all with a pretty smile, of course. After a few months of watching George's health decline, Elvira moved to phase 2. While George was desperately ill after receiving chemotherapy, Elvira tearfully told George that he needed to give her durable power of attorney and other documents that would allow her to make decisions for him in the case he was incapacitated. After all, she was the one caring for him. She was the one who would be there for him in the end, if that time should ever come. After several days of tears and relentless pleading by Elvira, George agreed to meet with the lawyer Elvira had hired and who had prepared documents that Elvira had requested. The next day, they met with Elvira's lawyer, and George signed a durable power of attorney along with other documents that gave Elvira the power to make all decisions on George's behalf in the hands of someone trustworthy. These documents would give that person the ability to care for George, to pay his bills, to file income tax returns, to manage his assets, and to make critical decisions about his healthcare needs should he become incapacitated. It's a smart thing to have if the person you're giving this power to is somebody that you truly trust. I'm not sure Elvira is the one you want having that power over you. So, unbeknownst to George, the very next day, Elvira went to George's bank and used the power of attorney to add herself to George's accounts, giving herself rights of survivorship upon George's death. She did the same thing with his investment accounts. She also used a durable power of attorney to sell George's vacation home in South Carolina, along with other properties he owned. She deposited the proceeds from the sales into a joint account she shared with George. George, whose health was now in sharp decline, had no clue what Elvira was up to and no way of really discovering what was done. While snooping around George's papers, Elvira also discovered that George had some treasury notes and gold bars in several safe deposit boxes that she wanted to get her hands on. So at this point, George's cognitive abilities were failing him. Elvira took George back to her unscrupulous lawyer friend, who she's probably sleeping with, and had George sign off on a new will that revoked his old will and left everything to her. She had George disown his rotten kids, even including a statement in the will explaining that George intended to disown his rotten kids who never visited him at the end of his life, never called him, and only cared about his money. Ironic, right? Well, 3 weeks later, George died. Most of George's assets passed to Elvira by operation of law because of Elvira's manipulations, except for the contents in the safe deposit boxes. Elvira, who wanted it all, commenced a probate proceeding for George's will. When the kids discovered what Elvira had done, they were outraged. They hired a young trust and estates litigator to object to the probate of the will and attack the transfers Elvira made using the durable power of attorney. So, how does it all play out? What are the kids' rights? And can Elvira get away with it? In probate, we always look for potential defects and formalities surrounding the execution of the will. As I discussed in my last video, probate is the process used by the surrogate's court to determine if a last will and testament is valid and enforceable. For a will to be valid and enforceable, the testator must follow specific rules and formalities as defined under state law. In particular, the testator must be of legal age, over 18, not too hard to do. The testator must intend for the document to function as a will. As lawyers, we call this testamentary intent, and we'll talk more about this in a few minutes. And the testator must sign the will, okay? There must be at least 2 witnesses. In some states like Maine, it must be 3, but 2 witnesses who are not disinterested, don't have an interest in the will, aren't getting anything. And ideally, the will is prepared by an attorney and notarized. If any of these features are missing, the will may be deemed defective and will not be admitted to probate. Here, George was of legal age. He signed the will. Some employees from the attorney's office will attest to him seeing him sign the will, and they believed he understood what he was signing. So the only question will be whether George had testamentary intent. As shitty as a lawyer was who prepared this will, it was still prepared by a lawyer. And when a lawyer prepares a will for a client and it's witnessed by 2 disinterested witnesses and notarized, at least here in New York, there is a presumption of testamentary intent. The presumption may be overcome, but that will be a burden that's placed on the kids to produce evidence that George could not have testamentary intent. The burden, though, will be on the children to prove that George lacked testamentary intent to execute the will. Now, for a testator to have testamentary capacity, the testator must understand 3 basic concepts. 1, the document they're creating is a will. 2, the amount and type of property they own. And 3, they have to understand who will inherit under the will. If the testator did not have the mental capacity, cognitive ability to understand these concepts due to, say, Alzheimer's disease, dementia, a stroke, or another disabling ailment, in George's case, late-stage brain cancer, the will may be thrown out by the court. Clients are always shocked when I say there's a chance the will may be thrown out by the court, even with a diagnosis of dementia. It's never a slam dunk, no matter how compelling my clients believe the facts are, and they may be very compelling. You see, even if a person suffers from a condition that may impair their capacity to execute a will, the legal standard for testamentary capacity is low, and it's lower than the standards for, let's say, a contractual capacity. People with serious cognitive impairments can have lucid moments, which means they can have a good enough understanding of what the will is and what they're agreeing to be deemed to have testamentary capacity. This is always fertile ground for litigation. In our case, the kids will argue that dear dad had late-stage brain cancer and suffered from a cognitive impairment at the time the will was executed, and therefore lacked testamentary capacity. To prove this, it would be really helpful if George's medical records showed that he was suffering from a severe cognitive impairment at the time and could not make financial legal decisions on his own behalf. Even if the records don't say this exactly, an affidavit or testimony from a treating physician to this effect would also be very helpful. Other people that interacted with George at the time or around the time the will was executed, especially people with no interest in the outcome of the case, can also be valuable evidence to support the kid's position. Still, this is only one side of the story. Rest assured, Elvira will come up with her own witnesses, perhaps some friends, maybe her lawyer, and these people will say that George may have had better days, but he was very lucid when he signed the will. Some of Elvira's witnesses may testify that they had great conversations with George the day of the signing. He was really with it that day. He knew exactly what he was doing. Even if he thought Jimmy Carter was the president the next day, on the day he signed the will, he was as sharp as a tack. This is going to be another factual dispute. Unless the case settles, it is likely that this is going to be a fact that will need to be decided by a judge or jury. And anytime a fact is left in the hands of a judge or jury, anything could happen. The story doesn't end here, fortunately. The kids have a good basis for arguing that Elvira exercised undue influence over George to get him to execute documents like the will and the durable power of attorney. If a will or testamentary substitute like bank accounts are the product of undue influence, those transactions can be invalidated by the court. Undue influence can be argued whenever someone uses a position of power to coerce a person in a weaker position to give the person in power property that the weakened person otherwise would never part with. Here, if we take all the facts at face value, Elvira was in a position of power over George. She threatened to leave George unless he turned over assets to her. George was sick and dying and relied on Elvira for his daily care. If Alfred and Betty and Carol can prove that Elvira used undue influence to coerce George, cut them out of the will, and transfer all of his assets to Elvira, a court can direct the assets Elvira received as a product of that undue influence be turned over to the children. Proving undue influence does not require any evidence of actual threats by the person in power. Instead, the injured party, like George's children, will only need to present evidence that shows that the influencer, here Elvira, took advantage of a close, confidential, and fiduciary relationship with the asset owner for their own benefit. In our story, Elvira's scheme is a textbook example of the use of undue influence. Even with such egregious facts, though, Elvira will have defenses. So Elvira may have a friend or two or three that have no interest in the case and may testify that George was very hurt and disappointed by his kid's actions at the end of his life. That witness may tell the jury that George decided to change his estate plan and leave everything to Elvira because she took such good care of him and stayed with him until the bitter end, whereas kids did not. Elvira's story may be pure fabrication, but ultimately it will be up to a jury to decide who's telling the truth, Elvira or the kids. It's never a sure bet that justice will prevail in a case like this. Finally, the kids have a little bit of ammunition left. They can also argue that Elvira breached her fiduciary duty to George to deprive them of their inheritance. Remember, in our story, Elvira had George sign off on the power of attorney, and the very next day she went to George's bank and investment firms and had those accounts changed so that she would be added as a joint tenant with a right of survivorship, which means that the funds from those accounts will pass automatically to her after George dies. Elvira may have a good explanation for doing this, but the optics don't look good. Elvira also used her power of attorney to sell George's vacation home and rental properties in South Carolina and put that money into a joint account that she had with George, and that would pass to Elvira when George died. Elvira owed George a fiduciary duty to use the powers that George gave her for George's benefit. But here we see that she really used those powers for her own benefit. So based on these facts, kids have a pretty good argument that Elvira breached her fiduciary duty to George and the kids. On its face, the kids have a good argument. Elvira didn't leave herself without a defense, though. Elvira is a clever con artist. She didn't put the sale proceeds from the homes into her own personal accounts. Oh, no. She put those proceeds into a joint account with George. Of course, Elvira was taking care of all the finances, and naturally she changed the passwords for those accounts and all the account statements sent to her in paperless form through email. So George really had no idea what was going on in any of their joint accounts. But as you can bet, Elvira will bring in friends and they will say that they had conversations with George and he knew all about the transactions and that he wanted all the money to go to Elvira. Elvira will argue that the assets were in a joint account, so George, at least in theory, could access them anytime he pleased. Of course, she had no intention of stealing those assets. If she wanted to steal the assets, she could have just put the money into her own personal account. Once again, it will be left to a judge or jury to decide which side is telling the truth. Who is going to win this battle between children and evil stepmother? Maybe some bad facts will be uncovered during discovery. Maybe the kids will discover that Elvira sent some emails to a friend saying she's going to take George for all he's worth. In truth, it's rare that you find smoking guns like that, but it does happen every now and then. If we're going solely based on the facts as presented here, however, it's really anyone's guess who will win in the end. The kids should win, obviously, but the justice system isn't always just. Trials are crapshoots. This is why it's important to have a skilled trial attorney, an appellate advocate with years of experience handling these cases by your side. Great lawyers cannot guarantee success, but they can help to improve the odds. Is there anything George's kids could have done to stop Elvira in her tracks? Well, in a perfect world, George's kids would have noticed the warning signs before Elvira could get her hands on the assets. If the kids were proactive, they could have petitioned the court to be appointed guardian for their father so they could protect him from Elvira. This would have put a huge kibosh on Elvira's plans. Unfortunately, the kids didn't talk to a lawyer before Dad died, and this option was never really considered. So while the facts in our story involve a large $20+ million estate, elder abuse cases like this happen all the time to people that are wealthy and poor alike. If there's somebody and they have money and they're in a weakened state, they are unfortunately available targets and victims of nefarious people like Elvira. While victims with the wealthiest estates end up in the case law more often, that's only because there is enough money at stake to justify the cost of litigating over these issues. The scheme Elvira pulled off could easily have been perpetrated against a person with a much smaller estate. If the victim was conned out of, say, $100,000, it would unfortunately be hard for the victims to justify the litigation costs to recover that money, making it that much easier for the crook to get away with it. I hope you enjoyed this video. If you found this video helpful, please press like and subscribe below. Please leave any questions or comments you have in the comments section. And if you believe that your inheritance has been stolen or you're being wrongfully accused of stealing an inheritance, I'd be happy to speak to you, especially if you live in New York. I'll leave the link to my law firm's website in the description below. Thank you for watching and have a great day.